we've learned about Supreme Court opinions, we need to learn how to brief court decisions. So, case briefing is a study tool that simply summarizes the core components of a court decision, and there are 5 or 6 components that you want to cover in a case brief. So, you want to include the facts of a case. You want to have the issue. Then you want to identify the court's holding, and the rationale, or sometimes this is also called the analysis. Then you want to have the rule of law that the case stands for. And then finally, if it's important, you can also include any concurrence or dissent. So let's go ahead and deal with each of these in turn. And so while the order of a case brief is usually written as facts, issue, holding, and then rationale, I'm actually going to encourage you to start a case brief by identifying the issue of the case. And the reason for this is because once you have identified the issue, it will make it a lot easier to figure out what facts to include. So we'll start with the issue. Now, there's a couple of rules that you want to keep in mind when writing your issue statement. So the first rule is to focus on the substantive issue and not the procedural issue. So, for instance, it is very easy to fall into the trap of writing an issue statement as something like, did the lower court err in ruling for the respondent? You want to avoid issue statements like that. Issue statements that just focus on who wins or what the ultimate decision was. Instead, you want to try and suss out the substantive issue, which is going to be about the legal question that decides the case. Something like, is a lawnmower a motor vehicle for purposes of the Grand Theft Auto statute? That's a good issue statement because it tells us what the precedential value of the case is and not just who wins the case. It's also not very helpful to write procedural issue statements because most of the cases that you read are appellate court decisions. So every one of those cases is going to have an issue about whether the court below erred or whether the respondent should have won. It's just not very useful. So try to figure out the substantive issue, the issue that has precedential value and will help decide future cases. The second rule that you want to follow when writing an issue statement is to allow the issue statement to have a yes or no answer. And this will lead you into the holding portion of the case brief, which will simply be an answer to the yes or no question posed in the issue statement. Now, from here, you have a couple of options for how to structure the issue statement. So you can either take a traditional approach, or you can take what I'll call the modern approach. So let's start with the traditional. So the traditional issue statement is one sentence. and that sentence starts with the word whether, and it ends with a period. Okay, so going back to our motor vehicle example, a traditional issue statement would be something like whether a lawn mower is a motor vehicle under the Grand Theft Auto statute. Period. So notice we start with the word whether, it's one sentence, and we end with a period. Now let's talk about the modern approach. So the modern approach is multiple sentences, and that's usually three, but only 50 to 75 words. Okay, so already you can see that the modern issue statement is going to give you more flexibility, and it's also going to be a bit more detailed than the traditional issue statement. The second rule for modern issue statements is that you end with a question mark. And then the basic structure is to have these three beats. And so that's why there's usually three sentences, although it's totally fine under this modern approach if you need to have more than three sentences to hit your beats, um, that works as well. So the three beats, let me scroll down here so we have some more space. So the three beats will have your governing rule. So this is sort of the first beat, and then the second beat has your trigger facts, and then the final beat is the question of whether the rule is triggered by the facts. So I am going to show you an example of a modern issue statement using the case of Gideon versus Wainwright, which was a really important Supreme Court case that ensured that people who were charged with a crime, who were too poor to afford an attorney, would be able to have the court appoint an attorney to represent them. So here is this issue statement. So, the Sixth Amendment guarantees the right to an attorney in all criminal prosecutions, which is fundamental to a fair trial and thus binding on the states under the 14th Amendment. In this case, the defendant was prosecuted by the state, but he was too poor to hire his own attorney and was forced to stand trial without one. Did the state violate the 6th and 14th Amendments? So, you can see that I have my first sentence here. The Sixth Amendment guarantees. This first sentence states the rule that is going to be governing this case. Then, in the second sentence, which has the second beat, in this case, and then I have my trigger facts. So he's a defendant, he's prosecuted by a state, he's too poor to hire his own attorney, he's forced to stand trial without an attorney. Once I have that, I move on to my question of whether the facts trigger the rule. Did the state violate the 6th and 14th Amendments? And I end with a question mark. This would be a modern issue statement. A traditional issue statement would just say something like whether a defendant who is too poor to hire an attorney must be appointed an attorney under the 6th and 14th Amendments. Now, there are advantages to both styles. A traditional issue statement is a bit more compartmentalized, it doesn't get into the facts, and so it's a little bit easier to come up with. A modern issue statement is has more moving parts. You can see it sort of has a quick summary of facts. It states a rule of law, and it also provides that yes or no issue slash question, all in one package. And it's a bit tricky to come up with a modern issue statement like that right off the bat before you've even really dived into the case. But if you are able to get it right, it really forces you to understand what's going on in the case. Now, ultimately, it's up to you to pick what style works for you, and it's also fine to make the issue statement sort of your own thing, or to even switch back and forth depending on what case you're dealing with. Remember, case briefs are just a study tool, so it really just depends on what is the most helpful for you. So I'm going to move back. So let's go ahead and move on to the facts section of the case brief. So the facts section should be pretty straightforward. So like the issue statement, you want to focus on the substantive facts and not the procedural history. So I would advise, unless it's important to the case, don't go off talking about the different courts that heard the case and how it snaked its way through the appellate process. Just talk about what was actually the facts of the dispute that led to the case being brought in court. And in particular, you're going to want to focus on this idea of trigger facts. These are the facts that trigger a rule that ultimately causes a particular outcome in court. And again, it is not super easy to figure out what the trigger facts are until you know what the issue of the case is. So it is generally better to figure out what issue you're dealing with before you try to sift through the facts. A lot of court decisions are also not good at keeping their statement of facts succinct and relevant. So a lot of times you get a bunch of irrelevant facts that don't matter to the case. And in your case brief, you really want to cut out everything that's not necessary to the decision and just get to these, like I said, trigger facts. Now, once you have the issue and facts down, then you want to move on with the holding. And you can also, if you so choose, combine this with the rationale. And rationale is also sometimes referred to as the analysis. And the holding is just going to resolve the issue. In other words, answer yes or no. And so this is really and so obviously this doesn't work if you've used a traditional issue statement, because if you have something like whether a uh, whether a defendant who is too poor to hire an attorney is entitled to have one appointed for him, it's not really going to make any sense to answer that in a yes or no fashion. So you instead would just have to rewrite the issue statement as a sort of declarative statement. But if you use the modern approach and you end with a question mark and you have structured the question so as to have a yes or no answer, then your holding can just be yes or no, and then you move on to the rationale. So the basic idea is that the holding is quite short. It's only going to be one sentence or perhaps even one word, and then you move on to the rationale, which of course is just explaining why the court decided to rule the way that it did. So finally, once you have that, then you can move on to the rule of law. And this is the real important one for your having a study guide, because the rule of law is something that you can quickly reference to and associate with this case that you've been learning about. So that if you have to write, an essay question or something like that, you can immediately identify that a certain case stands for a particular rule of law. And so the important thing for the rule of law is that you want to keep it succinct, something that you will be able to recall at a glance. So you see a case, you read the rule of law, and then that reminds you what the case is all about. And you want to incorporate elements of the issue, holding, governing rule, and rationale. So I would recommend that you start the rule of law with the word when, or you can also use an if then statement. So, returning to our Gideon versus Wainwright example, the rule of law that Gideon versus Wainwright stands for is that when a defendant is charged with a crime in state court and is too poor to hire an attorney, comma, the sixth and 14th amendments require the court to appoint an attorney. So you see that I have started this rule of law statement with the word when, and that naturally leads me to recite the trigger facts. So you have a defendant, that defendant is, so you have a defendant, that defendant is charged with a crime, and that charge is filed in state court, and the defendant is too poor to hire an attorney. So these are the trigger facts, and then those trigger facts activate the governing rule, the 6th and 14th Amendments, and then that leads to the outcome that the court must appoint an attorney to represent the defendant. Okay, so that's the rule of law, and then the final section of a case brief, which is optional, is to include the rationale of the dissent or concurrence. And as you should recall, dissent and concurrence are not binding precedent, so you may think to yourself, why should you include it in a case brief? And there's a couple reasons why it might be useful to include these. So first, sometimes the dissent or concurrence gets adopted later as binding. So sometimes you have a Supreme Court decision that is really bad in hindsight, and when that happens, we sometimes look at the dissent from that bad opinion and draw inspiration from it. Uh, that can also happen more rarely with concurrences. So sometimes a justice just writes a really good concurrence in a case, and later justices look back at that concurrence and later adopt the reasoning in the concurrence in a binding precedent. The second reason why you might want to include the dissent or the concurrence is to appreciate debate or nuance. So this happens a lot with like constitutional issues. So sometimes you get a set of facts that the justices all agree are, bad, but there's a debate among the justices as to what constitutional provision governs. So in that situation, you may want to include a dissent or concurring opinion just because there's an ongoing debate over what the governing rule is.